Welcome to the Beverly Hills Bar Association's monthly ADR section meeting. As we know, ADR is one of the hot topics of interest in our profession, and deservedly so. And the title of today's presentation is Maximizing Arbitration Efficiency. I'm Robert Cohen, co-chair of the section, and I'm delighted to introduce today's guest speaker, Aaron Gothelf. Aaron is the Regional Vice President of the American Arbitration Association's Commercial Division for California. He serves as the national chair of the AAA's entertainment practice. He is the ambassador for the AAA ICDR Foundation and is a council member of the ABA's dispute resolution section, where he formerly served as an educational programming officer. He is chair of the ABA's Forum on the Entertainment and Sports Industries, and also with regards to the Motion Picture and Television Division. He is a member of the ADR Committee for the Litigation section of the California Lawyers Association and is rotating host for the ABA podcast series Resolutions. So I must comment, I don't know where you get the time to do all this, Aaron, but we're thrilled to have you here, and let's get started.
Well, thank you very much, Bob. You make me sound a lot more impressive than I really am, but I'll take it. Okay, so folks, I'm going to share my screen so we can start the presentation. And all right, Bob, does it look okay? Do you see the title slide there?
Yeah, it looks great.
Okay.
Looks totally great.
Fantastic. Well, welcome everybody to Maximizing Arbitration Efficiency. This is a program that I put together a few years ago, and I certainly update every couple of years based on my experience being at the AAA now the last 6.5 years and prior experience with other ADR providers. Trying to restore the promise of arbitration, which is supposed to be a faster, more cost-effective way to resolve disputes than court. It's particularly important now to kind of follow some of those ideals as the costs of arbitration have significantly risen. And it's not necessarily always the arbitrator's fault. Sometimes the parties are really going at each other and creating a lot of billable work. But whether you're an arbitrator listening in today or you're an advocate, I think there's takeaways that kind of both groups can get to kind of streamline their arbitrations and hopefully get them done a little quicker and certainly save some money. So I will advance my next slide. All right, so has arbitration become general litigation? Now, as we mentioned, arbitration is not supposed to be general litigation. This is supposed to be a faster, more cost-effective way to resolve disputes, and that's the goal. But we've seen over the last couple of years, at least with some cases at AAA, and just my observation of cases in general, that advocates are starting to bring in a lot of what they use in the courtroom into arbitrations, and that's starting to slow down the process and make things more expensive. The single most expensive, kind of longest period in a lot of arbitrations these days is actually the discovery period. It used to be the evidentiary hearing period, and that's because the amount of discovery these days being asked for in cases is pretty significant and mirrors kind of the amount of discovery that one would ask for typically in court. Right. I always say, and I speak from experience, that a well-drafted arbitration clause is the basis for a cost-efficient, effective arbitration. And for those of you, and maybe a tiny handful of you that actually still do transactional work and clause drafting or whatnot, these are things that you'd want to pay attention to. So I always say a poorly drafted arbitration clause is like you're driving down the highway, right? And you get a little pebble hits your windshield and there's a tiny crack, right? Well, it's not a very big deal. It's just a tiny crack. You don't have to worry about it for the time being, but over the life course or the life cycle of a contract, that crack is going to get bigger and bigger and bigger. And when it finally comes to the point where there's a dispute, the windshield's going to fail, right? And so it becomes a bigger deal. Poorly drafted arbitration clauses often result in a couple different things. So the first one is failure to meet the parties' expectations. Well, the reason people draft arbitration provisions into contracts in the first place, as opposed to just leaving it blank and heading to court for all their disputes, is a faster, more cost-efficient way to resolve disputes. Well, if that's no longer the case, what's the point of having an arbitration provision? Some people might say confidentiality, and there's a couple of other advantages to it. But really, the reason people are doing this is to resolve disputes quickly and efficiently. Costs that spiral quickly out of control, with the advantage going to the side that has more money to spend on the process. So what I mean by that is arbitration over the last couple of years has basically become weaponized, if you will, by the side that has more money, as we say, to spend on the process, right? And that was never the goal of arbitration. Arbitration is supposed to be a completely neutral, uh, fair process to both sides. So what I mean by that is the side that has more money to spend on the process is going to start filing kind of silly motions that don't make sense, asking for exotic types of discovery, like forcing the arbitrator to do a site visit. Let's say a site visit isn't necessary, um, demanding the arbitrator sign hundreds of subpoenas to do hundreds of depots and crazy stuff like that, right? Things that, and for relatively sometimes small disputes. And the whole end game of all that is to force the other side into throwing their hands up, saying, "All right, I can't afford this process anymore. I give up. Um, let's settle." And you're forcing them into a less than desirable settlement agreement. And when we evaluate arbitrators here at AAA, and we evaluate them on a couple of different aspects, two areas that are commonly attacked are: do you feel that basically the amount that you paid for the arbitration, the number of hours that, say, the arbitrator billed, was proportional to the size of the dispute, right? And unfortunately, a lot of arbitrators who tend to let discovery and things like that get out of control score very poorly in that category. And another thing that we rate arbitrators on, these are, when I say rate arbitrators, I mean we send surveys to the parties at the end of a completed arbitration, is do you feel that they effectively managed the case from appointment to conclusion? And sometimes when things are getting really expensive and drawn out, arbitrators score poorly in those categories. And oftentimes you'll find this probably interesting. We don't, a lot of folks think, well, if I get slammed in an arbitrator survey, it's going to be coming from the side that lost the arbitration. Uh, and they're just sour grapes, right? Naturally, they're gonna be biased. They lost their arbitration. They're gonna slam me in some sort of review. These days, we actually get a lot of negative surveys back from the winning side, or the side that got the settlement. So technically, if you got a settlement, I'm not saying that's the same as winning an arbitration, but if you got a number you're okay with, you should have nothing but glowing things to say about the arbitrator. But sometimes even those folks throw the arbitrator under the bus. Unnecessary court intervention. Now, this is something that's not discussed a whole lot in arbitration programs, but let's talk about when the court steps in. So we talked about arbitration being a faster, more cost-effective way to resolve disputes. Another reason people choose arbitration is the whole confidentiality of the process. Faster, more cost-effective way at resolving a dispute and confidentiality both go completely out the window when the court has to step in. You see this, unfortunately, more than it should happen, especially in California. Some aggrieved side at any stage in the arbitration process is going to file a TRO in court. They are going to sometimes, as defendants, name the arbitrator, sometimes name the arbitral institution. Heck, I've seen case managers named in these lawsuits, right? And they're going to ask a judge to stop the whole process because something they don't agree with that the arbitrator or the institution's doing is going on. That's always a bad situation. And I noticed that there seems to be a higher percentage of these situations when an arbitration clause that is poorly drafted or ambiguous or has conflicting terms within it finds its way into a contract. Never ceases to amaze me. I'll look at a contract that could be 100 pages long, and the arbitration provision is one sentence buried somewhere on page 89, section 2E or something like that, right? You say to yourself, someone spent a ton of money and a ton of time drafting this very elaborate contract, right, with all these contingencies and things like that. And they put a one sentence arbitration provision in it. buried towards the back. Really makes you think, right? For those of you that draft arbitration clauses, why are we not drafting more stronger arbitration clauses, but clauses that really make things more clear? Because nobody wants to, when you're entering into a contract with somebody else, nobody expects the contract to be breached or something bad to happen, but we really have to be prepared for that possible eventuality. All right. The arbitral process itself being blamed for the unfortunate result, not the poorly drafted arbitration clause. Again, when we get surveys back on arbitrators, and arbitrators are, receive poor results, it might have had nothing to do with the arbitrator in the first place. It might have just been the arbitration clause was so poorly drafted that a number of bad things happened during the life cycle of the arbitration that wouldn't have happened had the arbitration clause been more clear on points. All right, drafting arbitration clause options. All right, so we have the arbitration rules to apply in the arbitrator selection process. So I just want to make this very clear. There are providers, whether it's AAA, GMs, or other providers, have tons of different sets of rules, right? So there's no such thing as the American Arbitration Association rules, right? We've got commercial rules, we've got construction rules, we've got consumer rules, we've got all sorts of different rules. If you don't say the specific type of rule set that you want to use from the provider, that can cause a lot of problems when a case might kind of fall into two sets of rules. And now an arbitrator has to make a decision, right? Or the institution has to make a decision, kind of which track to kind of put an arbitration in. And this is the first thing that people can fight about. Not too long ago, I had a case where it was technically a partnership dispute, right? Which would fall under the AAA commercial rules. But the partnership dispute was over a partner being essentially wrongfully terminated from the company, which had a number of employment issues, the reasons why this person was terminated. And there was a big fight about whether this was going to proceed under the commercial rules or the employment rules, because the clause didn't say commercial or employment, and the results could have been very different depending on what sets of rules you go with. For example, with the employment rules, typically the employer pays for the costs of the arbitration. So in this case, the claimant didn't have a lot of money, again, to spend on the process, but if the respondent was paying for everything, maybe they might have had a different result. Who knows? Arbitrator qualifications. Now, I think it's always great to kind of put in some guidelines and what type of arbitrator you want to hear the case. So I mentioned that I am the entertainment chair for AAA's entertainment practice nationally here at AAA, just based by the fact that I'm a regional vice president located in California, right? So let's say we have a profit participation dispute or something like that, and we have a case where you'd obviously want an arbitrator that's experienced in film and television profit participation disputes, right? So you might put into the arbitration clause must have a minimum of 10 years experience with profit participation disputes or something like that, right? I think this is really important for things that are more technical, like engineering cases or some of our more complex intellectual property cases. There are people that will always say, just, put together a rank and strike list of folks available in my area. I'd like to see, a combination of retired state and federal judges and attorney arbitrators and all that. And I'm less concerned necessarily about the technical experience or their background as far as the cases they hold. But that's pretty rare. And my warning against using somebody that already doesn't have some technical expertise in the dispute type is that's going to get really expensive really quick. When you have somebody that doesn't understand the subject matter, a lot of these arbitrators are oftentimes going to bill you, the client, for the time it takes for them to kind of learn the subject matter area. And they might ask for a lot of excessive extra briefing and things like that on things too, so they can learn as they go along. Single arbitrator or panel of 3 arbitrators. All right. A 3 arbitrator panel is going to be 4 to 5 times more expensive than a single arbitrator panel. And you might say to yourself, well, Aaron, wouldn't it probably on average be like 3 times more expensive? And the answer is no, because typically the chair is going to have to bill a lot of additional hours just for the privilege of supervising the wings and the work that they do. So very expensive, very costly. I'm not a huge fan of uh, three arbitrator panels for a lot of disputes, unless we're talking about a tremendous amount of money and controversy. We're talking about like tens of millions of dollars, right? Or $100 million or $1 billion. When you're dealing with numbers that big, sure, have a three arbitrator panel, right? It's a relatively minor cost compared to the size of the contract. But when I see a three arbitrator panel, you know, over the course of an arbitration, billing 600 or $700,000 in arbitrator deposits for $1 million reward, and there isn't a cost shifting provision, meaning the party that wins the arbitration isn't entitled to recoup the costs of attorney's fees and arbitration costs and that kind of stuff. It really makes me scratch my head at whether this was a faster, more cost efficient process. Right. Um, Governing law, not only substantive law, but also whether the procedural law, the FAA or state act. In California, we have the California Arbitration Act, right? So, if you're dealing with contracts with parties in two different states, you're going to really want to be specific about this. Again, if you're not specific about it and you have parties in two different states, they're going to have to spend excess money, extra money briefing the arbitrator on their positions, which state's laws govern. The losing side in that decision might not like that, and they might run to court, right, to try to get a judge to reverse the arbitrator's decision. Again, makes things very expensive. Locale of the arbitration. So the location of the evidentiary hearing is sometimes called the seat of the arbitration. This, again, should be one city, one state. If it's international, one city, one country, one city, one province, whatever prefecture. I don't know which terms you want to use internationally. I do occasionally see this left off of out of arbitration provisions, and it becomes a huge deal, right? Because typically the parties can't agree necessarily on the location. We have an internal committee at AAA called the Administrative Review Council that hears disputes like this, at least initially, requires the parties to submit briefing on their positions on both sides. And this is, again, extra expense for your clients, paying you for the time preparing the briefing on these types of issues. And again, if the losing side in this decision doesn't like the decision that the AAA Administrative Review Council has come up with, they're going to file a lawsuit in court. And that's just, again, going to make things more expensive and take more time. Confidentiality. Will the award be made public? Any issues like securities disclosures? All right, well, the general presumption is arbitration is supposed to be a confidential process, right? But there are always going to be situations where the law requires the results to be made public. So, for example, we had a situation where large publicly traded company got $100 million award written in their favor. That amount of money cannot simply come into a publicly traded company without some sort of SEC disclosure or disclosure to the shareholders, right? And so that became kind of a big issue, right? And an arbitration provision could have really spelled that out a little better. The discovery process. I've seen all sorts of exotic things written into arbitration provisions on the discovery process, everything from limiting the number of depots that can be taken, or outright prohibiting any depots from being taken, or tying the amount of discovery into the amount in controversy. And I think sometimes tying the amount of discovery allowed into the amount in controversy makes a lot of sense. Remedies, including emergency relief. Emergency arbitrations happen pretty rarely, but sometimes if there is a procedure added to the arbitration provision that explains what happens when a party needs a decision like right now and can't go through the whole typical life cycle of an arbitration, what should happen in those situations. Assessment of attorney's fees and other costs in a prevailing party, sometimes referred to as a cost shifting provision. And you're going to be really want to be specific here. We get this all the time. Arbitration provision says that parties are entitled to recover their costs, right? And the provision says arbitration. It says attorney's fees, right? So what does the party do? The winning party submits an award application for attorney's fees, arbitration costs, basically everything from the deposits that were paid to the arbitrator to the costs of their hotel room to their meals to all sorts of things, right? Well, you should be specific here. Do you just mean attorney's fees are recoverable in a cost shifting provision, or do you mean the entire cost of the arbitration? If you're not clear, the arbitrator might not have the authority to award you everything that you're looking for if it doesn't say so in the arbitration provision. And then last, the type of arbitration award sought, standard reasoned, a simple award, etc. If it's a sizable case, it probably makes sense to have a reasoned award where everything is clearly spelled out. But for a small case, maybe a couple $1,000s in controversy or something like that, doesn't make any sense for an arbitrator or arbitrators to draft a 20 or 30-page reasoned award. All right. If you learn nothing, if you're an advocate that still drafts arbitration provisions and you learn nothing else from my presentation today, pay attention to this slide. All right. You can put an unlimited number of things into an arbitration provision. Literally, you can put whatever you want, but at a very bare minimum, you have to have these five items. Why did I choose these 5 items? Well, these are the 5 items that are most commonly fought over, right? So the first one is the rules to be used. I don't care if it's JAMS or AAA or whoever it is that you're using. You need to be specific about the rules. So in this case, I wrote AAA commercial rules because that's a specific rule set within AAA. And I work in the commercial division, right? So those are the rules I'm most familiar with. Location of the evidentiary hearing, sometimes referred to the seat as the arbitration. Again, one city, one state. I see too many times 2 different cities listed as options in 2 different states and no explanation as to who gets to choose which of those venues. Now, there's a general presumption that the filing party gets to choose in that situation, but if that's not explained in the arbitration provision, that's something that people can fight over. Will the arbitration be heard by a single panel or a panel of 3 arbitrators? And I always want to say this, be specific. Use the term single or panel of 3 arbitrators. Do not rely on the word arbitrator or arbitrators in the plural to convey this, because there have been courts that have ruled that the word arbitrator in the singular can refer to a single arbitrator or the actual panel itself. So you don't want to get into that mess. The states whose laws will govern the arbitration, especially important when you have people in 2 different states. So you want both contract law as well as procedural law. And then does the arbitrator have the authority to award attorney's fees and costs in the arbitration of the prevailing party? And what constitutes those costs? So you're going to want to be really specific and break down exactly everything the entire prevailing party is entitled to. If the entitled party, if it's your intention that the prevailing party is entitled to nothing, you should simply explain that in the provision that both sides are responsible for their own costs and that there is no cost shifting provision to the prevailing party. Just be specific about it. Okay. I'm not going to read this entire thing to you because when I do presentations, I don't like just to sit here and read. But this is a example AAA commercial arbitration clause that I created with a service called clausebuilder.org, which is a website that you can go to and basically draft arbitration provisions that you can draft into contracts. We also at AAA have something called clausebuilder.ai that we're testing. Encourage you to play around with that as well. But this is basically whatever arbitrators providers rules you use should pretty much look the same. This is an example of a contract that has basically arbitration provision that has all 5 things that I discussed within it. I was doing a presentation for at the University of Washington School of Law. So I guess I left over the old arbitration provision here because it has a lot of stuff related to Washington in it, but just replace that with California. All right, selecting the right arbitrator. So the right arbitrator for your case is the arbitrator with the correct subject matter expertise, right? That's pretty straightforward right there, right? And we talked about this. The less subject matter expertise they have in a particular subject matter area, the more time they're going to have to spend learning the subject matter area, and the greater chance that they don't understand it and they make a misapplication of law. think beyond the rank and strike list. And if you have a good working relationship with opposing counsel, why not select the arbitrator together? This is something that's not discussed enough. And let's just talk about rank and strike lists for a second. Have a lot of arbitrators in my panel, especially arbitrators, let's say, that don't get a ton of arbitrations, and they simply think that if they get listed on more rank and strike lists, somehow that's going to lead to an increase in the number of cases that they get. And the truth is, there's actually no correlation between the number of rank and strike lists you're listed on and how many cases you might get in a given year. I can show you somebody who was listed 10 times that got 9 appointments out of that, and I can show you somebody that was listed 120 times that got 3 appointments. There's no connection there. The truth is, for large complex cases, in my experience, more and more we are seeing parties decline the option to receive a rank and strike list. They are wanting to select the arbitrator on their own. And that can be anything from as simple as me providing an arbitrator search link and them kind of looking through all the arbitrators we have nationally and resumes and who might work well. Sometimes we have situations where it's a party appointed arbitrator situation and the parties already know who they want, and then those 2 party appointed arbitrators select the chair, and the party appointed arbitrators work together in the process. There's a lot of different ways you can go about it, but the best results are going to be if you do have a collegial relationship with opposing counsel to kind of sit down and say, hey, let's you've used arbitrators in the past, we've used arbitrators in the past, kind of like what have your experiences been with X, Y, and Z, and then just kind of working together on that. Utilize the ADR provider's staff. Remember that case managers are experts in identifying the best arbitrators for your case. They spend a lot of time putting together arbitrator lists, so don't hesitate to be specific about what you're looking for. Just because a certain area of expertise might not be on an arbitrator's resume doesn't mean it doesn't exist, is what I always say. So if you have a resume of an arbitrator in front of you and you say to yourself, this person looks really good, but man, they're missing this one critical area of expertise that I think is relevant to our case. Before you strike that arbitrator or cast their resume away, it might make sense to reach out to the case manager and say, hey, can you talk to the arbitrator here and see if they have experience with this particular area? I'd be interested in possibly learning a little bit more about them. And they're more than happy to reach out to the arbitrator and get a statement on that. And then one area which I don't think is used enough at all is, at least at AAA, and I'm sure other providers will do this for you as well. There is the option of jointly interviewing a potential arbitrator candidate before deciding to select them. These interviews are going to be conducted jointly with both sides on the call or the video conference, whatever it is, along with the case manager. Remember, these are not opportunities to argue your case to a potential arbitrator and kind of try to figure out which way they would go on stuff. This is more just an opportunity to ask them about their experience and their subject matter expertise within your particular type of dispute. Again, both parties or all parties, if it's more than just 2 parties to an arbitration, need to be on the interview call jointly to avoid any kind of ex parte communication, or so both sides can make sure that the other side's not somehow baiting the arbitrator or putting ideas in the arbitrator's head that would affect the arbitration. All right. What steps can the parties take before the preliminary hearing to promote efficiency? So for those of you that are not experts in arbitration or have never done one before, the preliminary hearing is going to be the first time that the arbitrators actually arbitrator or arbitrators interact with the parties. This is the meeting where we go over the discovery process. We pick evidentiary hearing dates. We, everything that needs to go into the initial scheduling order is discussed. So some arbitrators are going to have a checklist that they're going to ask be sent to the parties in advance of the preliminary hearing. And they're going to require the parties to meet and confer and kind of fill all the information on their little checklist. And if there are things that the parties can't agree to, then at the preliminary hearing, that's when the arbitrator is going to basically, I don't want to use the term rule on those disputes, but let's say even out those disputes. All right. Length of final hearing in 2 or 3 mutually convenient sets of dates. Okay, so you typically don't necessarily know the arbitrator's availability uh, prior to the preliminary hearing. You can certainly ask their case manager just kind of for a general idea of that, but it's good to have a couple of sets of dates to match the arbitrator or arbitrator's schedule. All right. It is extremely important to understand third party, I don't want to say third party, but other people's availability outside of counsel and the arbitrator. So, for example, in this case, witnesses, right? What is witness availability? If your clients are going to be part of the evidentiary hearing or want to attend the evidentiary hearing, you're going to want to get their schedules, all that kind of stuff. Confidentiality and protective order requests. I think the best practice on any of this is to have the protective order requests already kind of agreed to up front and just ready for the arbitrator's signature at the preliminary hearing. That's going to save a lot of time. Again, sometimes there are fights over protective orders and people can't agree to what should be in it. And in that case, yes, arbitrator needs to step in and make a decision on that. Cybersecurity issues and how electronically stored information will be transferred and stored. Again, cybersecurity, ESI information, very important. There should be some protocol discussed in advance. What file sharing service you're going to use and what the security settings are and all that kind of stuff. You should always have a discussion with the other side about clawback protection and what would happen if there was some sort of inadvertent disclosure and how that would be handled. The type of award you expect. So I use the example of a reasoned award, but you can also have simple award or concise finding of facts, all sorts of different types of awards. Again, for relatively smaller cases, might not require a reasoned award, but I would say for any dispute where the anticipated award is at least $1 million or above, you probably want some form of reasoned award so you can kind of look through it. Again, I'm not ever suggesting a losing party vacate an award if there's no basis to vacate an award. But let me just say this. If you want to vacate an award, or even if you just want, if you're the winning side and you want that award enforced in court, it does tend to help to have that reasoned award available for the judge to review so they have some idea to how the arbitrators came to that conclusion. All right. What state's laws govern the choice of law provision that we discussed? Very important. Sometimes if that is missing, and again, we don't have, we have parties in 2 different states, it's best to have the parties, before they get to the preliminary hearing, already have this argument between themselves as to which state's laws would apply both substantively and procedurally. You'd actually be surprised at how many times that can be worked out before it goes to an arbitrator. And then, are there any jurisdictional issues to proceeding in the arbitration? In the AAA rules and in most provider rules, the arbitrator has the authority to rule on their own jurisdiction. This has been backed by the courts. There is case law that supports this. If one side really feels that they're not a party to a contract, or let's say it's a situation where the respondent is almost more of a third-party respondent, not a first-party respondent, and that's always very controversial. It would be a good idea for the parties to kind of have a discussion about that going into the preliminary hearing, just so everybody knows what's on board as far as next steps go. Sometimes, if a respondent really feels they're not part of a party to an arbitration, they might say outright, like, listen, I'll play along with this process for a little while, but if the arbitrator doesn't let me out of this arbitration on some sort of dispositive motion or something like that, I am going to go to court, file a TRO to stop this arbitration and get a judge to reevaluate the arbitrator's decision. Okay. Other things to meet and confer on is the case proceeding under the correct rules. Again, we use this example when you don't say which type of provider, specific rules within a provider set to use, there's going to be an argument about that. Can the scope of the arbitration be narrowed? You'd be surprised when if you sit down with the other side, how many things you can actually narrow. And that's going to make your arbitration a whole lot more efficient and cost a whole lot less. Are there any issues that can be resolved prior to the preliminary hearing? Again, a lot of people file arbitrations with no intention of ever going to an evidentiary hearing. And I've got to tell you, well, I don't case manage a lot of cases these days. The handful of cases that I do manage are all, 7, 8, 9 figure cases. And Um, 80, in my experience, at least the cases that I've managed, 80% of those have never even gotten close to an evidentiary hearing, let alone an award, right? So a lot of things can be resolved relatively early in the process, including sometimes the entire case can be wrapped up prior to the preliminary hearing, and that way you'll get some money back, usually. Um, has an early neutral evaluation session taken place? So an early neutral evaluation, or ENE, something I highly recommend. Having an expert come in and kind of sit and give you both sides their opinion of the case and say, listen, you can spend all this money on the arbitration, but in my experience, I've seen exactly the dispute happen dozens of times, and this is kind of what the value of the case is worth. Some people also do an early mediation. Um, Early mediation is fine as well. What I would recommend with an early mediation is do not do the mediation unless both sides have done at least some sort of limited discovery between each other, because in my experience, early mediations tend to fail when neither side actually knows the true value of their case. And you'll sometimes see in arbitration provisions that require a mediation as a step prior to even the filing of an arbitration being allowed. Um, the times where that is successful are going to be when there's actually been some discovery that have been taken place. All right. Will a counterclaim be filed? If I'm the claimant, that's going to be really important information for me to know. So you should just flat out ask the respondent. A lot of times respondents will be dodgy about that. They'll say, well, I don't know. I've got to talk to my client. Maybe we will, maybe we won't. As you know, a lot of counterclaims are filed purely in a defensive mode. They might not actually even have any value behind it, but it's going to add money to the cost of the process, especially if you're going to try to knock out their counterclaim on some sort of type of dispositive motion. The next line right there, is a motion for summary disposition likely to be sought? That's important to know because that's going to be something that's going to be taken care of relatively early in the process. But it will also make the process longer, so you might have to kick out your evidentiary hearing dates. Will subpoena requests, will there be subpoena requests, and will those be challenged? I think it's important before even the preliminary hearing for you to sit down with the other side and talk about witnesses and who's getting subpoenaed, and are we doing depots? Are we just doing this via interrogatory? All that kind of stuff. So you can have a concise list of bullet points during the preliminary hearing to say, hey, we sat down with the other side. We plan on doing this type of discovery and subpoenaing these people and this and that. And we talked to their side about this. We met and conferred, and they've said yes to the following people, and they've said no to the following people. And we'd like to discuss the folks that they said no to. Again, there might not be time to do all this at the preliminary hearing. There might have to be a second follow-up hearing specifically on subpoena requests that are being challenged. But, it's important to kind of have this discussion up front. Has a mediation been scheduled? If so, when? Um, Again, I recommend early mediations if there's been some sort of type of limited discovery. Once you've had the preliminary hearing, or at the time during the preliminary hearing, a good arbitrator will always set a mediation cutoff, a deadline for mediation to take place. At AAA, for all claims in excess of $100,000, we have in our rules, at least the commercial rules, construction rules, the requirement that the parties make a good faith attempt at holding a mediation prior to the evidentiary hearing to hopefully wrap up their case a little bit early, save them some money, whatnot. Unfortunately, either party can stipulate out of the requirement. So I don't like that part of it. And sometimes it happens. Sometimes the parties say, no, we don't think a mediation would be useful. The other side's being completely ridiculous. I don't want to waste my time. I don't want to waste my client's money on a mediation. When that mediation is being scheduled, you should pay particular attention to the cancellation periods for your arbitrator or arbitrators to make sure the mediation takes place enough time, enough weeks or days ahead of that cancellation period, and with a buffer between when the mediation is taking place and when you go into their cancellation period. There's nothing worse than the mediation is successful, but it took the parties a couple of weeks after the mediation to kind of reach a settlement, and you're too close to the date of the evidentiary hearing. So now the evidentiary hearing can come off calendar, but you still have to pay whatever cancellation fees are attached to whichever arbitrator. And for the arbitrators that are actually on this presentation today, especially the arbitrators starting out, this is why I recommend having a cancellation period as short as possible, like a 7-day cancellation period or a 14-day cancellation period. If your cancellation period is 30 days or 60 days or 90 days, especially when you're starting out, you're not going to get selected for cases unless you're some like amazing state or federal judge that's just coming off the bench that everybody loves. Maybe in that case, you can get away with it. But an attorney arbitrator, never in a million years, because when it's coming down to selecting folks, and I can tell you, like, this is one of the things that they look at, because a lot of times parties are going to settle disputes right up until like as close to the evidentiary hearing as possible, just because they're busy working on other stuff and they're going back and forth. A lot of times they're using the evidentiary hearing as a threat to force one side into a settlement. So this is just one thing to keep aware of. And then draft a proposed joint scheduling order if possible. So at AAA, and I'm pretty sure at JAMS and other providers, the case manager will send out in a PDF or an editable Word document, just a blank general scheduling order with fill in the blank kind of sections and all that kind of stuff. If you can fill all that out or as much of that out as possible prior to the preliminary hearing, get that off to the arbitrator or arbitrators, you're going to have a really fast, efficient, quick preliminary hearing. Okay. During the preliminary hearing, so the things that you want to do, you're going to discuss page limits in any briefing, right? If you don't have page limits on briefing, and we have parties that are submitting 50, 100, 200 page briefs and thousands of pages of exhibits, that's going to be very expensive. So one way the arbitrator or the panel can cut down on costs is to have page limits on things. For those of you that are advocates, if your legal secretary keeps your calendar, they absolutely have to be on the call with you. There's nothing bigger than a waste of time where we go through this entire process and then we're discussing dates and the arbitrator says, okay, what dates do we want to do this evidentiary hearing? And the attorney goes, I have no idea when I'm available. My legal secretary keeps my calendar. That's a cop-out. That's an excuse. That's completely unacceptable. So if you're going to throw your legal secretary under the bus, make sure they're on the call with you. If you want to get really exotic, also, and your clients are going to need to be available for the evidentiary hearing, you can also invite them to the preliminary hearing if you feel that that would be useful. A word on inviting clients and possible witnesses to that might be possible witnesses to preliminary hearings or any type of meeting with the arbitrator or the panel of arbitrators. Do not invite clients that have a hard time not saying things during these calls that might get them in trouble or create some sort of bias in the mind of the arbitrator. Remember, the arbitrator is your judge. They will be making decisions. If you have a hothead client that likes to yell or say random things that could damage their case just unannounced, then you don't want them anytime on any of these calls with the arbitrator. Set the preliminary hearing within a reasonable time frame, even if dispositive motions are planned. Yes, I get this all the time. The respondent says we can't discuss evidentiary hearing dates today because I plan on filing a dispositive motion. I'm pretty sure I'm going to win. That's fine. Just you can build that into the timeline, maybe push the evidentiary hearing dates out. But in the off chance you don't win and get the case disposed of on your MSJ or whatever it is, you want to have all those hearings set so we don't have to have a second preliminary hearing all over again. Discovery should be tailored to the complexity of the issues, right? So it's typically much more limited in arbitration than court. We all know that. Let's not have 7,000 depots being taken, 1 million pages of interrogatories, and all that kind of stuff. Really, still these small things. All right. Narrowing the scope of the hearing. I'm going to go a little quicker because I notice I'm taking a long time on these first slides. And you want to set a reasonable deadline for filing the dispositive motions, not always the threat of doing it, and then the dispositive motion filing ends up happening on the eve of the evidentiary hearing. That is absolutely ridiculous and unacceptable. Consider a joint stipulation of facts, what both sides agreed to, and then set hearing limits and a mediation cutoff earlier in the process, as we discussed. All right. Save a lot of money here. The streamline 3 arbitrator panel for large complex cases. My understanding is all providers offer this option, but certainly AAA does. All right. So option 1, essentially, you can have basically just simply appoint the chair, right? and the chair hears all discovery disputes and everything leading up to the evidentiary hearing, and then you can appoint the wing arbitrators later in the process. It's going to save a ton of money and a ton of time if you don't have three people reviewing and ruling on discovery issues. Other option would be to appoint all three folks up front. They all attend the preliminary hearing, but then either the chair or one of the wings is appointed to hear all the discovery disputes, and then we repanel or unpanel all three together if it actually goes to an evidentiary hearing. So the two things that are going to save a lot of time and a lot of money are either of these. All right. Video hearings in time of COVID and beyond. Just here's the thing. Video hearings are the way, since COVID, are very common now. I would say, in my experience, the majority of the evidentiary hearings that I handle, even though COVID's over, are still being either handled entirely via a video conference, or at least the witnesses and folks outside of counsel and the arbitrators are a hybrid, if you will, appearing via video hearing. All right, so COVID's over, so we don't have to talk about regulations and things like that for being a thing, and testing and masks and all that kind of stuff. If COVID ever comes back and you're deciding whether to do something in person or via video hearing, ask yourself a couple of questions. So, for example, as an arbitrator, can I judge veracity if someone is testifying and their face is behind a COVID mask? It's kind of hard if you can't see facial expressions and things like that, right? So in that sense, you might just want to do the whole thing on video conference. Issues that should always be discussed: is it going to be recorded? Is there going to be a court reporter? If you're simply just going to record the Zoom session, who's going to have access to that recording, right? Is it going to be a video hearing or a hybrid hearing? It's always important, if you're doing things via video conference, to have fail-safe in case the video fails during the process. What happens if someone's video fails? Do we stop the entire arbitration at that point? Is there a backup conference line that people can dial into at that point? You should always provide hard copies of all the exhibits and all that for the arbitrator, the arbitrators, as well as opposing counsels, so they can flip through things if for some reason there's some sort of failure there. And then, of course, there's a lot of court reporting companies and depot companies that are now providing really fancy video hearing services. It should be discussed in advance who exactly is paying for that hearing, video hearing, if it's not going to be split, because it can get pretty expensive, actually. All right, drafting effective pre-hearing filings and briefs. Again, you want to set the stage for your case. You want to begin with a succinct preliminary statement, right? You don't want to overpromise. You want to tailor it to what you're going to be presenting. And you should definitely learn from the dispositive motion rulings. If you lost a couple of these along the way, try to figure out why you lost them and try to see that as a positive as far as how you can help that with your case. Obviously, you want to provide e-links for any cases that are cited in your cases. That's going to be important. There's nothing worse than making your arbitrator at your expense going back in and having to, shepherdize or go to Westlaw or Lexis and relook up all these, and consider in limine motions, right? Presenting witnesses and evidence, again, considering a joint stipulation of undisputed facts. Decide with your fact witnesses whether they're going to be offering direct testimony and either by live or sworn statements. Obviously, if you're going to make them come testify live, there's going to be an added expense for that. But on the other hand, it's really harder to kind of cross-examine if it's just going to all be done on sworn statements. Expert witnesses, consider hot tubbing. For those of you that don't know what hot tubbing is, it's basically having all of the experts there together. So questions can be fired off at them all as a group, as opposed to scheduling different experts for different days, one at a time. That really adds a lot of extra days of evidentiary hearing and get really expensive really quick. Using a witness's deposition for submitting depot experts in impeachment. I mean, the depots are already done, right? So this is something that's going to add to efficiency. And then arbitrator questioning of witnesses. Some arbitrators will directly question witnesses. Some arbitrators won't. Some judges in a bench trial might question a witness. Some won't. It all depends on who you get. I know in court it's very rare for this to happen, but I would say with arbitrators it's kind of 50-50 in my experience, whether they're comfortable directly questioning a witness or having a witness clarify something that they might not understand. Remember, arbitration is supposed to be less formal than court, so we kind of don't go with always the same rules, right? Whether a hearing is remote or live, be sure all exhibits are legible and manageable for the arbitrator during both and during the hearing. Obviously makes sense. Um, Discuss whether you want to do joint or separate exhibits. Obviously, joint exhibits are going to be a lot faster for the process. We don't have to have two separate exhibit books, all that kind of stuff. People flipping through books and this and that. All it just adds to time. And then consider the wholesale admission of exhibits as opposed to um, just individually one by one challenging things that have been put into evidence, which just takes a lot of time and costs a lot of money. All right. Closing arguments and issues of interest, costs, and attorney's fees. Again, we talked about this in a well-drafted arbitration provision. You should really spell out upfront exactly what constitutes arbitration costs, what constitutes attorney's fees, are they entitled to both, et cetera, et cetera. You It should be discussed as an instruction from the arbitrator exactly what they would want an attorney fee application to look like. So extra stuff isn't thrown in there, just adding to the costs of the process. Closing arguments, again, my recommendation for you is be succinct and direct. And obviously, this is not your opportunity to enter in things that weren't discussed prior at the evidentiary, things that can't be necessarily cross-examined. This is not your time to bring up completely new legal theories and things like that. You'll have your opportunity in post-hearing briefing to add some of that in because the other side can issue a response to anything that you write in your post-hearing briefing, essentially cross-examine what you just said in their own briefs. Post-hearing briefs, again, you want to focus on the strengths of your case. Just whatever you think that you did well in the evidentiary hearing. If there is something you forgot to bring up, again, you can add it into your post-hearing briefing because the other side's going to have a chance to respond to what you write. But I find making them as succinct as possible. If you submit a 50-page, post-hearing briefing, with hundreds of pages of exhibits and this and that, at a certain point, the arbitrator's eyes are just going to glass over, and they're going to start to lose track of exactly what you're talking about. So succinct is best. Attorney fee applications, as we said, the instruction should be given at the end of the evidentiary hearing. Please pay attention to what the arbitrator says, what they want to see in the application, and what they don't. Whether there's going to be an interim award issued or a final award. So in my experience, again, with most large complex cases, where the winning side is entitled to some form of attorney's fees and or arbitration costs, an interim award is going to be issued. So we'll find out who wins and what they get. And then at that point, the arbitrator will ask for attorney fee applications and whatnot. And those will be submitted. The other side will have an opportunity to challenge those. And then the arbitrator will decide upon a number of what's going to be given in attorney's fees and costs and add that to the final award. And lastly, should the parties draft a model final award together after the interim award is issued? This is, again, something that's only really works if both sides are getting along. Because oftentimes the parties, one party is pretty upset after they get the interim award, right, and they see that they've lost. But it'll save a lot of time and a lot of expense if the parties can agree to as many things that should kind of go in the final award as possible. I mean, I've had silly situations, everything from, I had a party that wanted specific language that the award was to be paid to the attorney's trust account and not paid directly to their client, right? Probably because their client owed them some money or something like that, right? And that became a big issue, right, between the two sides. And the other side was challenging it just to be difficult. Let's be honest there, right? So if things like that is the kind of thing that you would kind of add into an award. If you want in the final summary of the award, not just the monetary issues discussed, but also equitable relief and things like that that are discussed elsewhere in the award, to just make it clear for a judge that might have to read this down the line to enforce it, or if it's going to be some sort of vacature motion, decide that with the other side, right? And let the panel know that first, because it's very hard once the final award is issued to modify a final award. At AAA, it's a big elongated process, right? So you want to make sure that that interim award is as close to what you'd like to see as a final award as possible, right? So it goes in there. All right. If you guys have any questions, I've provided my email address here, gothelf@adr.org. I'm always happy to talk mediation, arbitration, any questions you might have. And I've left, looks like 5 minutes here for questions. So let me stop my share here. Okie doke. And let me see here in the Q&A, we've got some questions here. All right. All right, so we have a question here. Is AAA desk arbitration actually being used? Why is it not allowed, even in seven-figure or larger cases, if parties expressly agree? All right, so a desk arbitration, which I believe would be referred to as a paper arbitration, where there's not an actual evidentiary hearing. I'm not sure if that's what you mean by that, Jack, but different arbitrators allow different things, and that's just going to be at the discretion of the arbitrator. We've done paper arbitrations at AAA for up to any amount in controversy, so I don't necessarily, that wouldn't be an accurate statement. Okay. We had a question of what a clawback provision is. A clawback provision is what happens when information that's prejudicial to one party is accidentally released and how that would be treated in the arbitration. That's what that is. All right, what are the reasons for specifying FAA or the California Arbitration Act? Do either of those conflict with AAA or JAMS rules? All right, so within the AAA and the JAMS rules, there's always a rule that says if any of the provider's rules conflict with state or federal rules control the arbitration. All right, so that's basically our fail-safe in those types of situations. You should specify FAA or California Arbitration Act just because they're different, right? And while they're drafted very similarly, there are advantages and disadvantages over each. I could do an entire presentation on what those advantages or disadvantages are, but that's why you should be specific. And again, when you're dealing with parties from two different states, it's really important to specify that. How do you handle pre-arranged consent awards? So that's a great question. So first of all, let's talk about what a consent award is. At a certain point during the arbitration, usually right before the evidentiary hearing, or sometimes even during the evidentiary hearing, you might be 2 days into an evidentiary hearing and the parties both put up their hands and they say, stop. We've worked out an arrangement with the other side to create a consent award. A consent award is where both parties essentially agree to the award amount, how the award's going to be drafted, and all that. You simply draft the consent award with the other side and present it to the arbitrator for signature, and it's basically entered in as the award. Happens all the time. There are certain situations in a consent award where the parties might ask for the arbitrator to retain jurisdiction until whatever relief in the consent award has been provided. I don't always recommend that because we can't technically close our case file if you're asking the arbitrators to retain jurisdiction. And if we, for example, owe the money back to one side or the other, let's say there are unspent arbitrator deposits or whatnot, we can't return those arbitrator deposits until the parties both say, okay, the terms of the consent award have been completed. We no longer need the services of the arbitrator, which is why I'm not a big fan of that. Okay. Thank you, Andrew. I appreciate the comment. All right. How do you suggest the arbitrators handle the tension between following the party's lead on what discovery is necessary versus acting as the gatekeeper when it looks like the cost may not be in proportion to the amount of dispute? So, a lot of arbitrators, especially with the introduction of SB 940 and the changes to the Code of Civil Procedure and evidentiary rules, are very concerned about limiting discovery these days. They feel that if they limit discovery too much, the losing side, or the side that's most upset about the process, is going to run to court and get their award vacated or something like that because a certain amount of discovery wasn't let in. Again, this is me giving personal advice here. I'm not speaking on behalf of the AAA. I'm just speaking in fact with what I've noticed, and it's too early to kind of see how SB 940 is affecting this. Courts are generally aligned with, if a judge has the power to limit discovery, an arbitrator has the power to limit discovery. And I would always err on the side of limiting discovery more than letting in excessive discovery. And as an arbitrator, I think you should flat out call out the parties when they're doing something that is really simply just increasing the cost of the arbitration and might not necessarily be useful. I see arbitrators all the time deny discovery requests simply because they feel that it's excessive and it won't provide any additional information relative to the process. And once you say that to the parties, they'll usually back off on that position. Again, in my experience, award vacature happens because the arbitrator had some sort of failure to disclose issue that wasn't disclosed in the initial disclosures, and they failed to submit a supplemental disclosure necessarily where it came up. Almost never is an arbitration award vacated because a certain amount of discovery wasn't let in, or misapplication of the law, or the provider's rules weren't followed to the T, that kind of stuff. So, it's those types of situations are quite rare. Okay, we have one last question, I think, here. If the Zoom link wasn't given to one of the parties for the initial pre-hearing conference, how prejudicial is that to the evidentiary hearing if the evidentiary hearing goes forward anyways? Okay, so this really shouldn't happen, but occasionally we have situations where one side decides they don't want to participate in the arbitration provision. So let's say you're the claimant, you've served the respondent. The respondent never responds to any inquiries from the arbitrator, from the provider. We've tried to reach out to them a million times, whatnot. That doesn't stop an arbitration from going forward. It just means that we have a non-participating side. So a preliminary hearing will happen. It'll happen with the arbitrator, a member of the provider's staff, and whichever party decides to participate. That's not considered ex parte communication or anything against the rules, because anytime a AAA staff member is part of a discussion or on the call, that breaks the ex parte communication situation. Is it prejudicial? Yeah, it probably is prejudicial on some level, but again, that's really the side of the non-participating side's fault. If you're talking about a situation where the arbitrator or the other side or the provider, like on purpose or something like that, didn't invite one side to participate in the preliminary hearing and didn't provide the link on purpose or something like that, that's a very serious situation. And I would say that's extremely prejudicial, and that should be raised with the provider. Um, do, 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 do. Okay, we had some questions here about repeated player bias and about how CCV 1284.83 discusses that. I can't. With some of our consumer caseload, especially, there's going to be situations where the same arbitrator has had the same claimant or the same respondent appear before them a couple of times. This is always disclosed up front. The parties are given an opportunity to object to it at that point. At AAA, I can say that we do keep track of awards, and we kind of look at how folks are ruling on things. And while we would never step in and change an arbitrator's decision or something like that, because that's not our place, if we notice internally that any type of bias, or the arbitrator always rules a certain way for a certain client or law firm, or party, that kind of stuff is brought up with the arbitrator to make sure there isn't an issue of bias internally. But I can't speak about specifically to the act how that would necessarily apply.
Well, Aaron, I think you've given us a deep dive into maximizing arbitration efficiency, and obviously we could go on for hours talking about this. And I've enjoyed it very much. I know our panel, our audience has too. And we thank you for being here and providing such an incredibly in-depth overview. And I have many things to think about myself, and I'm sure everybody else does too.
Yeah, there's a lot of questions here. Yes, it's okay if you want to follow up with me if you have questions, answer that. There was one question here just really quickly. How does AAA deal with hybrid clauses where equitable relief is carved out for litigation and all monetary relief is set for arbitration, and a plaintiff files suit on both, and a defendant files a AAA demand that the plaintiff ignores? All right, that's super specific right there. That would come down to a decision that the arbitrator is going to make. So that's how I would answer that. Okay, that's it. Thank you all for joining me. And again, for questions that I wasn't able to get to, you can shoot me an email. And I'd like to thank Bob for inviting me to be a speaker today. And everybody have a great rest of your day. See ya.
Thank you. Bye-bye.
Bye.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.